All right. That's the right microphone up for sure. Hello again. This is Ben Hitchcock Cross talking to you today. We've got the Kimberly Hassel Fair Employment Decision from the Labor and Industry Review Commission. So Judge Schacht made a decision. I don't have that. We're not going to go that far into the weeds here. Ms. Hassel appealed that decision to the Labor and Industry Review Commission. That's a commission of 3 commissioners set up, appointed by governors. So it depends really when you file. That one of them focuses on the equal rights, another one focuses on employment, and another one focuses on kind of everything else. There's accommodation and so forth. That's the way I understand it. I've never seen them do that, but that's my understanding. Okay. So this then, and they can have, sometimes they'll have 2 people vote on one side and another person will dissent here. But hey, so we'll see what's going on. Dated and mailed February 1st, 2021. I think we're going to get the new in with the old here. All right. Kimberly Hassel versus UW Milwaukee. This decision of the administrative man, I was trying to hold it to the end, is affirmed subject to modifications. Accordingly, the complainant's complaint is dismissed. Michael Gillick, chairperson. Falstead, commissioner. Georgia Maxwell, commissioner. As far as I know, they're all still there. If you seek judicial review, this is to the circuit court. You must name the Labor and Industry Review Commission as a respondent in the petition for judicial review. Appeals rights and answers to frequently asked questions about appealing a fair employment decision to a circuit court are also available on the commission's website. How helpful. Procedural posture. This case is before the commission to consider the complainant's allegation that the respondent discriminated against her based on her sex and in retaliation for opposing a discriminatory practice. I'm going to tell you all that I have not watched all of the Hassel videos. So if I'm getting something completely wrong, please let me know. But certainly I got the gist, I felt. Okay. An administrative law judge here, and I don't. Let's be clear about this. I think this is why it's important to name the names. And for example, we read out a case some while back about an administrative law judge in the 80s who asked a county employee if she was carrying a gun to the hearing, and he did this on the instigation of a white county employee. I think a white witness. That person in 1980 who did that was James Schacht. So took some active investigation on our part to get the department to tell us that. And that's why I think it's important here that the names be named. So an administrative law judge, James Schacht, for the Equal Rights Division of the Department of Workforce Development, held a hearing and issued a decision finding no probable cause to believe that discrimination occurred. The complainant has filed a timely petition for commission review on that decision. Now, if you have a no probable cause, it's a pretty big blow, but the one consolation is the standard for getting to the next point, to having an actual hearing on the merits, is very low. So we're not talking about whether it's more probable than not that it happened. We're just talking about that there's enough evidence to go forward. That's really what we're talking about. So we always need to keep that in mind here. Sometimes the standard shifts on these here, but it's no probable cause the whole time. All right. The commission has considered the petition of the parties So that's the petition of the positions of the parties. That means after the decision, they each write briefs, and it has reviewed the evidence submitted at the hearing. Based on its review, the commission agrees with the decision of the administrative law judge, and it adopts the findings and conclusions in that decision as its own, except makes the following modifications. I skip these. There's two facts that well, I guess there's more. The respondent did not issue any performance review for faculty in criminal justice department, as there were no annual merit increases at that time. I don't know what any of this meant, so we'll just leave this going here. Memorandum opinion. This is, I think, what we want to talk about. In her complaint, the complainant alleges that the respondent denied her a one-time lump sum compensation bonus in the fall of 2016, and it provided her a false and negative performance evaluation in the fall of 2016. It's kind of shocking that it's taking this long to resolve these things, to the extent they're resolved, and that it excluded her from informal departmental and school processes and discussion and subjected her to increased scrutiny of her work performance and outside consulting projects. There is a footnote. And the complainant's complaint also included a variety of allegations stemming from events occurring in 2013, and a preliminary decision issued on May 26, 2017. An equal rights officer for the Equal Rights Division dismissed the 2013 allegations as untimely. The complainant did not file an appeal of that determination. Okay. I don't know what that's supposed to mean here yet. Let's also keep in mind that there's a distinction. The issue here is whether or not she should have got paid a one-time lump sum payment. The fact of whether they were discriminatory towards her, for example, in 2013, may not be at issue in terms of what if she got other payments in that time. But it is evidence of future discrimination. Because if they're discriminating back then, it's likely that they're discriminating in the future. So I don't know what that means there, and it's because it's not clear, but let's be clear about what the rule is. The complainant contends that these actions were taken because of her sex, and in retaliation for having complained to the respondent about discriminatory pay practices. Well, what do you think about that? She full of beans? Lump sum compensation award and performance evaluation. The complainant has alleged that she was denied a lump sum compensation award based on her sex and in retaliation for statutory protected activity. However, the evidence adduced at the hearing does not support these allegations. There's a lot in that word, right? However, the evidence adduced, I think if you'll just permit me here one, and as I'm sure you knew, and of course I always did, adduced is to offer something as evidence or an example. I mean, who doesn't know that? So, all right. On the other hand, if you're writing these, 20 of these a year and you're an attorney working for the Labor and Industrial Review Commission, you're going to adduce the heck out of it. You're going to, of your vocabulary. But, however, the evidence adduced at hearing does not support these allegations. And see, I think that lucky for us that we always had this definition at our fingertips, because there is, I think, some little contention about what evidence was allowed to be offered at the hearing. So to the extent that that verb indicates what because, the point of this whole thing is to put the blame on the complainant. I mean, as a rhetorical exercise here. I mean, it is. It's to say that there's either one, you've got one or two options in dismissing a complaint. You can say that because of some action or inaction of the complainant, it doesn't pan out, or you can say that the even though what the employer did might be morally reprehensible or what have you, it doesn't fall under the law. Those are basically the two venues. But I'm sure we'll read a lot more of these and we'll have examples. So if we find a third one or more, we'll have an opportunity to correct that theory. All right. But again, adduced at the hearing, that's not really fair to what happened, I think we could say. In a confidential vote, 2 out of the 3 voting members of the executive committee voted that the complainant was not a solid performer. She probably wasn't a member of the team either. One of those individuals was a male and one was a female. Oh, man. And as we all know, as a matter of law, females cannot discriminate against other females. That's a closely known corollary to the scientific fact that black people can't discriminate against black people. The female decision maker, Tina Freiberger, the department chair, testified at the hearing. Ms. Freiberger provided legitimate non-discriminatory reasons for her vote. She explained that the complainant focused on outside consulting that did not benefit the respondent, that the complainant was not present at departmental meetings, and that she did research but had no publications, and that the complainant had refused at the last minute to teach an in-person class, which caused a loss of enrollment and resulted in a lot of extra work for Freiberg. I would like to know not so much the, sex organs of the person making the decision, but possibly comparisons to other decisions that they've made. So if, for example, the person making the decision with female sex organs is making decisions consistently on behalf of males, that might be more important to know. But maybe they'll talk about that, maybe they won't. I don't know. But we've led with the sex organs of the decision maker, which, I did think. Okay, let me put it like this: when it frequently happens that people put that argument, the company will put that argument to the department, and I'm just like mind-boggling. We can't discriminate against black people because the person who investigated the problem is black. I've literally had that happen several times this year. Literally. All right. But it is from the record that the refusal to teach the class, which happened only a few months prior to the lump sum compensation vote, weighed strongly in Freiberger's decision to vote no. The record contains no evidence to indicate why the other individual on the panel voted that the complainant was not a solid performer. Everyone else on the department who was eligible for the award, including both male and female employees, was deemed to be... Do we have this? I guess I should have got the joke already. We'll get it. We will. I don't know. Rather, the complainant testified that she was deemed not a solid performer because of retaliatory behavior, and there was no other explanation she could think of for that rating. Was there no discussion of any comparison employees at all? Was that attempted to get in and not allowed to get in? What happened with that? Because there's a big gap in what I'm getting here. Rather, the complainant testified that she was not deemed a solid performer because of retaliatory behavior and that there was no other explanation she could think of for that rating. Review of the record also reveals no evidence of retaliation. Okay, so they're saying they independently reviewed. I apparently watched the hearing. Okay. There would be a transcript and it would be printed and written out only unless, only if somebody hires a court reporter. I don't think there was a court reporter there, so scratch that, okay? So then there's a recording of an audio recording, and here there's a video recording. So they're saying, and they're using the word review here. So, I will keep in mind that we're assuming that it's there's the panel goes like this: 3 commissioners, and then maybe 8, 10 attorneys, full attorneys that work underneath them that are working on this stuff. So commission can mean anybody, any one of those people, and possibly more reviewed, but somebody apparently watched this video too, or some part of it. But it says the record, so we're going to assume that somebody there watched this entire thing, watched what you watched. The complaint saw no evidence of retaliation. Okay. The complainant's protected activity, rising allegations of gender-based pay inequity, occurred 3 years earlier. That sentence doesn't make sense to me, but I hope it makes sense to you. The complainant's protected activity, raising allegations of gender-based pay inequity, occurred 3 years earlier, not close enough in time to infer a causal okay, so they are taking it as evidence, but they're saying that 3 years is too far between the two events. I mean, generally speaking, the question you're going to want to, jurors are going to want to ask is, if they want to get rid of you because of your gender, why would they wait 3 years to do it? Now, I've seen examples of that, but that's going to be something. So the point is that this is a totality of the evidence kind of thing, and you don't want to just have one thing that happened 3 years earlier to discuss. I don't know what else she had. You may. All right. The email in which the complainant raised her concern about pay disparity was sent to Dean Stojkovic. Oh, okay. And the complainant subsequently met with the dean on 2 occasions to discuss the issue. Sorry. I'm digesting this with you. However, Stojkovic did not vote on who would receive the lump sum compensation, nor did he discuss the vote with other committee members or suggest how they should vote. Okay, now, I just want to point out, I didn't see much of living on the east side of Milwaukee in the shadow of UWM for many years, you're going to know who Stan Stojkovic is. Okay? The one thing that I will say about that testimony that I found to be astonishing was the way that he discussed the chief of police, I think Chief Flynn, and like how he had Chief Flynn come into his car, and that that's astonishing in and of itself. And the way that he talked about how he had seen a number of people come and go. Now, he's supposed to be studying, among other things, these, I won't tell him his job, but I'll say the police activity involve a lot of what they are studying at under Stojkovic, okay? So, you can see why he's seeing them, I think, not only as people, fellow citizens, but also as subjects and, data implementers and so forth, okay? So, we saw that. I also saw a significant concern about you want to deal with somebody on their own, don't ever put our name into it because I'm not in control. And unless I'm not in control, you can't use UWM's name. Perfectly fair if that's what they want to do. I got it. But those seem to me the two things that he was most focused on. I will put it like this. In my experience, somebody who has that view of the chief of police of the city of Milwaukee is not going to need to tell anybody anything about how they should vote. So I just want to put that out there. I think I think that many people probably know that. And I'm guessing that Miller tried to get something like that out there. I also didn't see, for example, and this, it's hard to tell, but this, and hard to know how to do that. I don't know if there were many witnesses for Miller there. That's may have been something that would have been more helpful. I don't know. All right. But I will just say I'm very skeptical of this sentence. However, Stojkovic did not vote on who would receive the lump sum compensation, nor did he discuss the vote with other committee members or suggest how they should vote. Although Stojkovic did approve the recommendations of the executive committee, the witnesses at the hearing, including the complainant's own witnesses, testified that it would have been unusual for the dean not to do so. Okay. I don't know what that means. I mean, I get it that there's the process that he has the veto power and that he normally doesn't do that. But that could also mean that he doesn't have, because he doesn't have to, because they know what he wants. The lack of involvement in the process by Dean Stojkovic, together with the 3-year passage of time between the complainant's protected activity and the adverse compensation decision, weighs against any finding of retaliation. And concluding that, and remember, all we had to do here was to really have some evidence. I wonder who appointed the members of the committee. That would be something that I wouldn't sit well with me. But okay. In concluding that the retaliation was not established, the commission notes that Ms. Freiberger also knew the complainant had complained about pay. Oh, having been copied on the email to Stojkovic. However, there is no evidence. Well, is she on the committee? Okay, this is gonna be interesting. It's kind of bearing the lead. Also knew the complainant had complained about her pay, having been copied on the email to Stojkovic. However, there is no evidence to suggest that Freiberger was upset about the pay equity complaint, or that it colored her decision to raise the complaint as not a solid performer. Indeed, the complainant does not suggest that Freiberger was motivated against, because she's a woman, right? And her allegations of retaliation focus on Dean Stojkovic. Further, as indicated above, Freiberg provided legitimate reasons for her decision to rank the complainant as not a solid performer that were unrelated to any concerns about prior protected activity. Finally, there's no evidence to show whether other individuals, that's no evidence of any kind is what that's saying. Just to be clear, I don't know, but you tell me, that the complainant has not contended that the committee voted against the complaint, was aware of the prior complaint, and that the other, oh my God, sorry, there was no evidence to show whether the other individual on the executive committee who voted against the complaint was aware of the prior complaint, and the complainant has not contended that he was. Under all the circumstances, the commission sees no reason to believe that the vote of the executive committee was colored by retaliatory animus. Okay. In her petition for commission review of the complainant attempts to make a disparate treatment argument, the complainant argues that the male employee Steve Brandel, who did not complain about his pay, was given a bonus when she was not. Okay. The complainant contends that Brandel's brag sheet was similar to her own. I think that's what professors have to show their accomplishments. And that the only difference between them is that Brandel did not engage in protected activity. The commission is unpersuaded by this argument. While in her petition, the complainant argues that Brandel's brag sheet was finally we got a comparison here, was not any better or stronger than hers. The complainant did not elicit any testimony on this point at the hearing and did not ask Ms. Freiberger to explain why she considered Brandel to be a solid performer when the complainant was not. The commission is unable to determine simply by comparing their respective brag sheets that Brandel and the complainant are similarly situated with regard to their academic contributions. That means she didn't bring up enough evidence at the hearing, and achievements such as that they could be expected to receive the same rating from the executive committee. Ooh, a little footnote down here. Oh my gosh. Oh my goodness, people. We're going to read through this a little faster. In his responsive brief, the respondent asserts that the Professor Brandel had more teaching assignments. Oh, his bragging, he could just brag the heck out of her. All right. The evidence presented at the hearing does not require a conclusion that the complainant should have received the same rating as Professor Brandel. Moreover, even if the commissioner were to find that the complainant was treated unfairly in this process and that her academic contributions and achievement were not fully recognized, for the reasons discussed above, there is no evidence that this occurred because of her sex or in retaliation for having complained about pay inequities. The thing here that confuses me, and this is just going to go long, is I thought that they spent the last 2 pages before dismissing the evidence, but now they're saying there's no evidence, and that confuses me. They're saying it's too remote in time, and then they're saying there's no evidence. The complainant also argues that the methodology used to decide who was a solid performer was improper. The complainant contends that the respondent did not use established procedures, that it should have relied on former performance reviews, and that Dean Stojkovic required everyone to put together a one-page list of their activities in research, teaching, and service. The brag sheet, okay, but she could not list all of her accomplishments on one page. I would like to see the original arguments with that, but I guess we'll have to take it as written. The complainant further argues that the respondent's reliance on a secret ballot was in violation of the Wisconsin statutes governing open meetings. I'm just saying, I think there's, based on what I saw, Dr. Hassel, and that just seems, I didn't see her personality as being someone who's trying to overbrag. The complainant, the respondent's reliance on a secret ballot was in violation of Wisconsin statutes governing open meetings. I've heard that one argued before. These arguments are also unpersuasive. The commission initially notes that the complainant attended a meeting where the respondent explained what procedures it intended to use to assess who was a solid performer, during which she raised no objections. Although the complainant contends that she was not given a chance to object, Ms. Freiberg testified that everyone had a chance to talk at the meeting. It should also be noted, per the guidelines established by the Board of Regents, that the respondent could not use performance reviews prepared before, what, yada, yada, yada. Okay. Here's what I would like to see is some comparisons. Sometimes you don't need comparisons when you've got direct evidence. She apparently has a good email. Maybe it's 3 years ago. I don't know. But comparisons, especially with a thing like this where the question is, should I have gotten the money? And it sounds like there's a pool of people who got the money. I'd like to see what the pool is. Was there nothing on that? It seems it seems unlikely. I'm skeptical, but you know. Finally, even if the respondent did fail to use an established procedure or implement that sounds like an admission, a procedure that did not comport with the open records law, there is no evidence to suggest that any deviation from past practice, procedure, or failure to adhere to the statute was motivated by discriminatory animus. We assume that they violated their policy. It doesn't mean that they necessarily violated their policy. Maybe they're just idiots. Maybe they did it. The point is whether or not they did it because they are discriminating against the good professor. All right. Although the complainant maintains that Dean Stojkovic came up with the one-page brag sheet idea, Stojkovic testified that he was not the one who decided to have the committee use a one-page brag sheet, and Ms. Freiberg indicated that she could not recall where the idea came from. There is no evidence as to who chose the methodology used to determine which employees were solid performers, and nothing to indicate that the respondent's approach was selected with discriminatory intent. Well, I mean, you'd assume that it's the person who's been in charge there for 17 years. And if it was the secretary down the hall, the person who's still responsible for implementing that is still the person who's been in charge there for 17 years. The procedures applied to everyone in the department, not just the complainant. Look, that's right. Patches putting in that one. The city of Milwaukee used to have a racist test for detective, and it was available to everybody, not just the whites. It was also open to the blacks. They could also take the racist test. Everyone had to submit a one-page statement of their achievements, and no one was evaluated based on past performance reviews. All were evaluated based on a vote of members of the executive committee, only one of which got your letter complaining of pay-based inequities. And how many of which are under the thumb of Dean Stojkovic? I wonder. How about this? How many are wholly dependent on Dean Stojkovic for their livelihood going forward? How many of that? Can we answer that question before we go forward? That may be relevant here, I think. Was that allowed to be asked? Therefore, even if there were problems or irregularities with the procedure that was used, there'd be no basis to find that they amounted to a discrimination against the complainant. They just violated the law, but not just against her. Other discriminatory terms and conditions. The complainant engaged in protected conduct when she sent an email to Dean Stojkovic complaining about alleged discriminatory pay practices. We'll keep that in mind, everybody, for future reference. That qualifies here, apparently. The complainant testified that thereafter her relationship with faculty members changed and she became isolated. I wonder why this is at the end. Specifically, she contends she was left out of things. It does not say it does. Was not on marketing materials and was not a part of a discussion or email exchanges outside of formal faculty meetings. At the hearing, the complainant testified that when she attends departmental meetings, her colleagues do not talk to her. The complainant also maintains that there has been a heightened scrutiny of her consulting work, and that Dean Stojkovic wrote a letter to Chief Flynn and had the IRB investigate. Okay. Most of the complainant's complaints of adverse terms and conditions of employment are general in nature and unaccompanied by specific examples. The complainant's feelings that she is isolated is simply too vague and subjective to form the basis for a factual finding, let alone a conclusion that this occurred for discriminatory reasons. Okay. I just, so being left out of marketing material is too vague and subjective, not a part of discussions or email exchanges outside of formal faculty meetings. Is that also vague and subjective? I mean, do these emails not exist? Let alone a conclusion that this occurred for discriminatory reasons. Similarly, the complainant did not elaborate on her contention that her work is being subjected to heightened scrutiny and did not provide detail about the alleged letter to Chief Flynn or IRB investigation. Well, I heard Dean Stojkovic talk about that with the regard to the complainant's contention that she's not included on the respondent's marketing material. Dean Stojkovic testified that the marketing material was created by a separate marketing person and that he did not decide whose pictures went into the brochures. Thus, any exclusion of the complainant's image from the respondent's pamphlet or videos cannot be considered the result of discriminatory animus. Sorry, I see in here it says that she was, I see this thing that the marketing one, but it also says up here, and not part of discussions or email exchanges outside of formal faculty meetings. I don't see that addressed in here so far. Thus, any exclusion of the complainant's image from the respondent's pamphlet or videos cannot be considered a result of discriminatory animus. Under all the facts and circumstances, the commissioner can see no basis to conclude that the complainant was subjected to discriminatory terms and conditions of employment retaliation for a pay complaint or for any other discriminatory reason. Copy to David Pottinger and Jennifer Herzog. All right, I guess that is unanimous decision of Gillick, Falston, and Maxwell. So there we have it. It concludes the Hassel case as far as the state of Wisconsin is concerned. I don't know if she appealed this to the circuit court or not. But as far as we can say the Department of Workforce Development is concerned, I think we've wrapped that up there. So you tell me if you think that was the right outcome, because that would be something to hear. It tells you the importance of comparators and that decision feels like it could have been more internally consistent based on my reading of it. But let me know what you think. Take care.